Hi, I'm Ed Bacon, the rector of All Saints Church, Pasadena. Whoever you are and wherever you find yourself on the journey of faith, I hope that you'll find something here that speaks to you. Welcome.
Happy 4th of July, everybody. Happy 4th of July, everybody. Thank you. I'm very impressed that you're here. I'm sure we'll get on to our ribs and vegan burgers later on in the day. Being a great All Saints crowd, we'll have a lot of diversity in what we eat and how we celebrate. I want to especially thank Karen Smith for this wonderful sweater she's wearing today. It was a delight to see a flag sweater while I was preaching this morning at 9 o'clock. And I'm thrilled about this speaker. I do, before introducing him, want to tell you that there is some information from his organization, MALDEF, back there, and also we'd love for you to stop by and pick up that information. Also, at All Saints, we put our faith into action, and we call people to political action every Sunday. And most Sundays, that's about asking the president or senators or congresspeople or other legislators, either in Sacramento or Washington, to do something. And we've got three bodies that we've lobbied about comprehensive immigration reform and objecting passionately to the draconian law passed in Arizona, about which our speaker will speak. And they voted the right way. And so in order for us to maintain our effectiveness, it's important to thank these people from time to time. So if you have not signed the letters of gratitude to members of your city council, either Pasadena or Los Angeles, or if you live in neither of those municipalities, you can certainly sign a letter to one or more of the supervisors for the LA County. Please do so today. Our speaker is a nationally recognized civil rights attorney. He is now the president and general counsel of MALDEF. He was previously counsel to Los Angeles Mayor Antonio Villaraigosa. He served on the four-person executive team to Mayor Villaraigosa, where he provided legal and policy advice on major initiatives. During his 4-year tenure with the city of Los Angeles, he helped to lead the legislative effort to change the governance of LA Unified School District, the effect of which has been to take the city a step closer to securing a quality education for all students in Los Angeles. During the time that he was conducting the civil rights litigation at MALDEF, our speaker was a leader in the successful challenge to California's unconstitutional Proposition 187, and he led numerous civil rights cases in the areas of immigrants' rights, education, employment, and voting rights. He has many, many other victories under his belt, but I wanted to speak about the recognitions that have come his way. He was selected as one of Hispanic Business Magazine's 100 Top Influentials in October 2009. The National Hispanic Bar Association presented him with an award in 2008. In 2007, he received the Peace and Justice Award from the Institut de Educación Popular del Sur de California and the Latino Law Students Association of Yale Law School Public Service Award. He was born and raised in Southern California. He graduated summa cum laude from Yale University. He received his law degree from Yale Law School. He served as a law clerk to the Honorable Harry L. Hupp of the U.S. District Court for the Central District of California, and to the Honorable Stephen Reinhardt, a friend of mine, of the U.S. Court of Appeals for the Ninth Circuit. For 8 years, he taught civil rights litigation as an adjunct lecturer at the University of Southern California Law School. His board service I want to include because it connects us to him in a real way. Includes the Alliance for Justice, Los Angeles County Board of Education, the Alliance for Children's Rights, the Impact Fund, and Encompass, which was the nonprofit organization founded by our new director of OCC, Juliana Solano. So I am just absolutely thrilled to introduce to you and want you to help me warmly welcome a rock star of justice, Thomas Saenz.
Thank you, Reverend, so much for that generous introduction. I've never been introduced as a rock star of justice before, but I hope it sticks. Good morning.
Good morning.
And thank you so much for being here this Sunday, July 4th, as we celebrate the 234th anniversary of the signing of the Declaration of Independence. And when we celebrate our nation's birth as an independent country, we don't often recognize how critically important, even then, 234 years ago, the issue of immigration was. But the Declaration, as you all know, was really just an explanation of the grievances that the colonies had against King George. And among the grievances that Thomas Jefferson included in the Declaration of Independence was a grievance about immigration. Among the grievances were the following, referring to King George. Quote, "He has endeavored to prevent the population of these states, for that purpose obstructing the laws for naturalization of foreigners and refusing to pass others to encourage their migrations hither." So it's important to recall on July 4th that ours was a nation of immigrants from its very start. And 234 years later, with what has gone on in the neighboring state of Arizona, we continue to face concerns and grievances surrounding this issue. But it's also important to remember that 234 years ago, the country that we know today as a government, as a unified nation, did not yet exist. Indeed, the Declaration of Independence referred to the United States, small u, capital S, the United Colonies, small u, capital C, in the plural. Specifically, the Declaration stated that these United Colonies are, and of right ought to be, free and independent states. Now today, in 2010, of course, we refer to the United States in the singular. The United States is the leader of the free world. The United States is a leader among nations, but we say the United States is, as a single entity. But that was not always the case. And I fear that what we face today in the neighboring state of Arizona and in too many other states, including this state, where elected leaders and candidates for high office are seeking to enact their own versions of Arizona's SB 1070, we face a threat to that unity of nation that it took so long to realize. It took so long because initially, when the Declaration was signed, we did view each colony, each state, as an independent sovereign entity. But over time, of course, we came to refer to the United States as a singular entity. It's not often discussed that for the first 12 years of our existence, we didn't even have a president. For half that period, of course, we were at war with Great Britain to achieve and make real what was declared 234 years ago. But for the other half of that dozen years, we were tied together by the Articles of Confederation and not a constitution. The Articles knit us together, but not quite as a single entity. It was the Constitution that began the process that culminated, regrettably, in a civil war and the leadership of our greatest president in ensuring that we would be a single entity, not a loose confederation of independent states that could freely separate themselves from one another. But we have been a singular entity for some time, and that has its roots in the Constitution, adopted 222 years ago. Our Constitution expressly provides that this then somewhat loose confederation of states would assign certain duties exclusively the United States federal government. Among these duties, perhaps among the most important of these federal duties assigned 222 years ago, were the ability and authority to conduct relations with foreign states and the ability to establish rules of naturalization, referring to the immigration concerns that had in part motivated the Declaration of Independence 12 years earlier. It is these two powers over foreign relations and naturalization that have established for over 200 years that under our national constitutional scheme, only one government, the federal government, has the authority to regulate immigration. And indeed, it's logical that if we allowed Arizona to have its own immigration regulations, and California to have its own that deviated from Arizona's, and New Mexico to have its own unique set of immigration regulations, and New York and every other state, we would cease to be a single nation. It would no longer be accurate to refer to the United States as singular. We would have to revert to referring to them in the plural. The United States are a wonderful nation. Or in this case, it would be nations. But that is what is at stake with Arizona's SB 1070. Much like California's Proposition 187, enacted 16 years ago but struck down swiftly in federal court, SB 1070 is an attempt by Arizona to react, in its own leader's words, to the failure of the federal government to perform its duties and to take on the duties of regulating immigration. But under our constitutional scheme, no matter how much Arizona, California, or any other state may dislike what the federal government is doing in an area like foreign relations or immigration regulation, our constitutional remedy is not to do it ourselves. Our constitutional remedy for any state or states is to use our elected representatives to seek to change federal immigration regulation policy, to seek to enact different policies and pursue them on a nationwide basis. We do not have a self-help provision in our Constitution that if you don't like the way the federal government is doing something, you get to do it on your own. Because it knows if that was the case, we would probably end up with multiple kinds of currency, coinage throughout the nation. Immigration regulation is of the same kind. SB 1070, then, is a direct confrontation, a direct assault on a constitutional principle that has been with us for 222 years, even though it had to be reinforced through a civil war. That civil war, of course, had not only to do with preserving the United States as a singular entity, but also with removing the scourge of slavery that had been so much a part of our history, including its specific mention in our Constitution. Therefore, another result of the Civil War was the enactment of the 14th Amendment and its guarantee of equal protection to anyone living in the United States. What that has meant is a clear dictate that discrimination on the basis of race, discrimination on the basis of national origin, discrimination on the basis of religion, discrimination on the basis of gender are not allowed to government in the United States. Now, it is true that it took a long time after that Civil War, after the ratification of the 14th Amendment, for the equal protection guarantee to be made real. It was only 56 years ago that the United States Supreme Court unanimously decided in what was a change in our constitutional law that segregation on the basis of race was unconstitutional and would not be permitted to any state, including those states throughout the South that under the regime of Jim Crow seemed bent on ensuring they would continue to follow. That equal protection guarantee is also directly confronted and assaulted by SB 1070. SB 1070, as signed by Governor Jan Brewer in Arizona, not only requires every law enforcement agent in the state of Arizona to begin to enforce Arizona's own immigration laws. This bill creates Arizona's own crime, state crime, for being undocumented. This bill creates an obligation to determine whether anyone that an officer comes in contact with is reasonably suspected, quote unquote, of being undocumented. And if they are reasonably suspected by any law enforcement agent, it triggers a series of responsibilities, attempting to verify the status of the person, and if you can't verify the status of the person, detaining and potentially arresting and holding that individual for up to 6 months for violating that new state crime for being undocumented. Beyond that, because it requires police officers to engage in this mental calculation, do I have a reasonable suspicion or not? SB 1070 doesn't just invite, it positively mandates that law enforcement agents throughout Arizona engage in what has come to be known as racial profiling. This is because we know that Arizona police officers, never previously having been asked to enforce immigration laws, without adequate training, without any training in the complexity of our immigration laws, without any training in how to look for actions that might indicate someone is guilty of an immigration crime, are being asked beginning on July 29th to arrive at that mental calculation of reasonable suspicion or no with respect to every person they come in contact with. We know that without that training and recognizing that the act of being undocumented is a status crime, which is to say, there is no action that any police officer can witness. There is no recent action that a police officer can surmise has occurred and is being hidden. Unlike other crimes. If you're guilty of jaywalking, police officer sees it. If you're guilty of robbery, you may be in the process of selling the material you stole. You may be in the process of concealing your getaway. Those are actions related to the crime. That's what police officers are trained to do. But being undocumented is a status and not an action. Therefore, being required for the first time to enforce laws about status with inadequate training about those very laws, we know with strong support that law enforcement agents, including from law enforcement officers themselves, that law enforcement agents will rely on what any of us would rely on in a similar situation: stereotypes and assumptions about who carries that status of being undocumented. We can expect then that law enforcement agents in Arizona will rely on race, national origin, accent, language, last name, in making determinations about whether they have that reasonable suspicion or not. And that is the direct assault on our 14th Amendment principles. Let me assert to you that this assault is nothing new. 56 years ago, when the Supreme Court made that unanimous decision, a progressive movement to make our constitutional law more consistent with the principles under which our country was founded, it faced a reaction. Elected governors, the predecessors of Jan Brewer, like George Wallace, Orville Faubus, and others throughout the South, literally and figuratively stood to bar the doors of progress, stood to prevent the implementation of that progressive new interpretation of the Constitution. They defended their obstruction by uttering terms like nullification and interposition, referring back 234 years ago to when states were sovereign entities, arguing that they had the right, as governors, to nullify. the decisions of a unanimous United States Supreme Court. Let me assert to you that what we face today with Governor Brewer and gubernatorial candidates in this state, in New Mexico, and in other states across the country is a new nullification, a new attempt by governors to bar the doors toward progress. In this case, however, they seek not just to react to a new development in the law. Remember, the principle of only exclusive federal authority over immigration regulation has stood for 222 years. The principle of equal protection has thankfully now been with us for 56 years. So these new nullifiers are seeking to push our nation back. They are not reacting to a new development in the law. They are not attempting to prevent forward progress. They are attempting as a group to push our nation backwards. They are attempting to push our nation backward to a time when racial profiling was not a clear violation of the constitutional guarantee of equal protection. They seek to push our nation back to a time over 200 years ago when it was possible, theoretically, for a colony or state to adopt and pursue its own regulation of immigration and naturalization. This new nullification requires the same kind of response that those governors in whose dubious footsteps Governor Brewer and others follow, when those governors a half-century ago pursued their policy of nullification. Defeating it required leadership from the targeted community, powerful, strong leadership from the African American community. But it also required the alliance of good, progressive people from every community throughout the nation. Lawyers, reverends, business people, stay-at-home wives and husbands. It required a unified national effort to push back that nullification. This new nullification will require that kind of effort and more. We already know that some 22 states have had an elected leader or candidate indicate their intention to introduce and seek the enactment of a copycat of SB 1070. Although let me assert to you that a better term exists than copycat. It was only last weekend that I had a conversation with someone after speaking about this issue who pointed out to me that copycat just sounds too benign. It's a playground term. It sounds too playful for something so dangerous. And so I've decided to call these duplicitous duplications. We need to work together to defeat these duplicitous duplications, to prevent their replication. We need to work together to defeat this new nullification, to defend the constitutional principles and values on which our country was built, and which we, every single one of us, have expressed by our continued participation as voters or by our migration here, our strong, strong belief in those constitutional principles. That is what unifies us. That is what makes us singular. And together, we can ensure that we remain a singular United States. Thank you.
I'm going to ask you a couple questions before we open it up. I'm going to ask you about comprehensive immigration reform, how that works, and then what's going to happen in the appeal process.
Thank you so much, Thomas. Magnificent. Before we open up this, and let me tell you how it's going to go for those of you who are new, just raise your hand. We'll get to the microphones to you. We take the questions only through microphones so it can be on this tape, and we are streaming this through, people are watching us from throughout the country today. And before we open these mics, let me simply ask Thomas to address two issues. What is going to happen to this law now? Surely people of your caliber and vision, and all of us with you, Thomas, are going to find a way through some means to challenge it, hoping that the challenge would get all the way to the Supreme Court. If you could just kind of rehearse that journey for us. And then, after you've done that, and I'm sure you'll do that impeccably because you know the future like we hired you to come and talk with us about the future. But also, if you, while you have the mic, Thomas, if you could talk to us about what this thing is called comprehensive immigration reform. Our board here, called the Vestry, has passed a resolution about what that is. But I want this to be a teachable moment for all of us, simply for you to rehearse what the values, the core values and principles of that are. So if you don't mind addressing that two-part question.
You gave me the easy questions first. Yes. There is a challenge to Arizona SB 1070. Not surprisingly, like its predecessors, including California's Proposition 187, almost immediately there were lawsuits filed. One of those lawsuits was filed by MALDEF, together with the ACLU and the National Immigration Law Center and a number of other civil rights, labor organizations from around the country, have challenged SB 1070. It is now pending in federal court in Arizona. Soon after we filed that lawsuit, we filed a motion for a preliminary injunction that would ask the court to prevent 1070 from ever being implemented on July 29th so that we can determine its constitutionality before anyone is irreparably harmed by its being implemented. And the hearing, we just learned this week, on that motion for preliminary injunction is set for July 22nd. So a week ahead of time. But we've been there before. We've seen this before with Proposition 187. Unlike Arizona, after legislation is passed, there's a 90-day period before implementation. That's how we get to July 29th. In California, if you enact something by initiative, it takes effect the very next day. So with 187 in November 1994, we had to be in court the very next morning, seeking to prevent something from being implemented that technically had already been implemented for at least 10 hours. We got a temporary restraining order, a preliminary injunction, and that law was never implemented. 4 years later, there was finally a final permanent injunction. I expect a similar course here with 1070. We have a very strong case. The first claim is the one that I've described here this morning, and the one that prevailed in striking down 187, which is that this is Arizona's own immigration regulatory scheme that it cannot constitutionally adopt or implement. And the other standard that goes into determining whether you get a preliminary injunction is whether there is irreparable harm. And certainly anyone can understand the immediate irreparable harm of being detained, arrested, potentially turned over to federal authorities, potentially removed from the country, discriminated against if you're a U.S. citizen or a lawful permanent resident because someone has an incorrect but reasonable suspicion about your status. You can see the irreparable harm. We have a very strong case demonstrating both irreparable harm and a likelihood of succeeding on the constitutional merits. And that's a combination that should make an injunction very likely for us. I like our odds very, very much. But we'll know, hopefully on July 22nd or very soon thereafter, because the danger is that on July 29th, a lot of untrained police officers will be out in force and feel a tremendous pressure to not just implement, but over-implement this law. Because one element of SB 1070 that's not discussed as often as it should be is a provision that permits any resident of Arizona who is unsatisfied with any police officer or police agency and believes that they are not being suitably aggressive in enforcing this law to sue that officer or police agency in state court to seek to ensure that they are more aggressive. So with that threat over their heads, the danger that police officers will engage in unconstitutional profiling and feel compelled to over-implement this law is palpable. And that's why I believe it's imperative that we get that injunction. But the wheels are moving. Our court system is doing what it's required to do, and I'm confident that very shortly before the 29th we'll have an injunction preventing this from moving forward. Now, with respect to your second question, comprehensive immigration reform has been on our national agenda for over a decade. And the support of all Saenz and others has been critical to keeping it on the agenda. Although, as you all have seen in the last 2 years, it has not yet risen to the top of the priority policy list for the administration and Congress, and that is of concern. Comprehensive immigration reform would give us the opportunity to address the severe flaws in our existing immigration system at the federal level. I talked earlier about the need to prevent the new nullifiers from pushing us backward from a constitutional perspective. But comprehensive immigration reform provides an opportunity to push us forward from a constitutional perspective. It provides the opportunity for the first time to ensure that we have an immigration legal scheme at the federal level that is consistent with our established constitutional values and that serves our national interests. Immigration, because of its unique status, in that it relates to how we relate to the rest of the world, is not covered by our Constitution. So we have an immigration scheme today that in any other arena of policy or law would be declared unconstitutional because it discriminates on the basis of national origin. You often hear the rhetoric from the other side talking about how come those undocumented immigrants can't wait in line. Well, the truth is it's not one line. It's multiple lines, depending on your status and where you come from. So you can have two potential immigrants with the exact same relationship to someone who resides in the United States, and the only difference between them is that one comes from Europe and one comes from Mexico. Or one comes from Europe and one comes from China. The wait for those two immigrants would be 2 years in one case and over 20 years in the other case. I let you all guess which source country gets the 2 years. But that's because we have an immigration system adopted in 1965, more progressive than what we had before, which was more heavily weighted in favor of Northern and Western Europe, consciously on its face. But instead, we adopted a system that is based on the premise that the demand to immigrate to this country will be exactly the same from every country in the world, regardless of size, regardless of proximity, regardless of cultural connection. Our basic system's premise is we will set the exact same quota for every country in the world. Now, there are some immigrants who don't come under that quota, and that's why you have more immigration from particular countries. But for those immigration categories that fall within quota, that's why you have different lines. Now, again, if there was any other system where we said, you, because you're from a European country, your ancestry is from a European country, you have to wait 2 years for a government benefit, and you, because your ancestry is in an Asian or Latin American country, must wait 20, how quickly do you think a court would overturn that rule? It would happen in a minute because of that development of 56 years ago. But in immigration, we allow that because immigration is unique. We allow similar violations of due process, fairness, and equal protection that we wouldn't allow in other contexts. And comprehensive immigration reform gives us the opportunity to arrive at a system that better reflects those values and that better serves our national interests. Comprehensive immigration reform needs to include, first, a pathway to legalization for the millions of people who have toiled in this country over years and in some cases decades, contributing to our economy, our polity, and our society, raising their children to be United States citizens, raising their children in many cases to serve in our military, raising their children in many cases to go on to higher education and to be ready to contribute to our country. Second, we need to fix our future flow so it better reflects our constitutional values and national interests. We need a system that better demonstrates our belief in fairness and creates one line for the world. Third, we need to introduce better due process in our immigration adjudication system so we don't regularly see the kinds of violations that we see. Fourth, we need to ensure that our enforcement, federal, and to the extent we allow it, through memoranda of understanding, although I have severe doubts about the 287G program, to the extent that we allow it, local and state enforcement is consistent with civil rights protections in every other arena. These are daunting tasks, and accomplishing them will require us to accept certain other changes that will make me and perhaps some of you uncomfortable about enforcement. But we need to take steps now toward comprehensively fixing our immigration system. There has been a reinvigorated debate in the last week, in part catalyzed by President Obama's thoughtful and helpful statements reaffirming the urgency of addressing this issue. But there has been a reinvigorated discussion about whether we can make some initial steps, down payments, as I have called them, toward comprehensive immigration reform. And among those, and I've articulated this since I became the President and General Counsel of MALDEF some 10 months ago, ought to be the DREAM Act, which would provide a pathway to legalization for those who were brought here as children, as minors, and have done well in school, have gone on to military service or university education, and are ready and willing to contribute to our economy, but are denied the opportunity to do that by the fact that they don't have legal protection. The DREAM Act would provide that, and also serve our national interest in having an educated workforce. Second, ag jobs is a provision that recognizes that one industry, although there are many others, in this industry I think there is little or no debate, one industry, a critical industry to this state and our nation, depends on an immigrant workforce. There is simply no domestic workforce in agriculture. We have to have an immigrant workforce, but if that's the case, we need to have one that has legal protections. And ag jobs would provide legal protections and a pathway to permanent residence and citizenship for those who toil in one of our most arduous but critical industries. Third, the Uniting American Families Act is a recognition that we need to continue to consider primary in our immigration system the notion of family. And UAFA would recognize that the definition of family in 2010 has changed and must include LGBT partners, just as it does spouses today. UAFA would permit LGBT partners to petition for the immigration of their partners on the same basis as we allow citizens and residents to petition for their spouses to immigrate legally as well. Those are three critical steps toward comprehensive immigration reform that I think we ought to be debating in earnest, and I believe we have an opportunity before the end of this calendar year to make real progress toward comprehensive reform by enacting those provisions.
Questions, please. One up there. Question over here. One question over here. There's a question. Whoever has the mic in the very back there. Please, Keith.
Yeah, I have a two-part question. In a rare moment of insight from the mainstream media, Wolf Blitzer asked a question of a sheriff. He said, if you saw a group of white people outside of the mall, okay, would you go up to them? And then he said, if you see a group of, Hispanics outside of, say, I don't know, a grocery store or something like that, would you go up and talk to them? And the sheriff said that I would go up to the group of, Hispanic or Latino, whatever you want to say, and he said I would strike up a conversation in order to see whether, to investigate, okay? That sheriff is the same sheriff that is in the campaign ad for John McCain that endorsed him. And so my question to you is how could that not be? I mean, that seems to be unavoidable, okay? The second one is to sort of look behind the curtain and say, what is really driving these measures?
Two very good questions. I'll answer the second one first. I think that what's really driving this is politics. Governor Brewer was never elected governor. She succeeded to the position when Janet Napolitano was appointed by President Obama to be Secretary of Homeland Security. She's in a tough race to stay as governor. And I believe that she saw an opportunity, same way that Pete Wilson did 16 years ago here in California, to create a wedge issue and energize voters on one side of the political spectrum to come out and support her with strength. And she believes that SB 1070 and her championing of it will permit her to retain the office of governor. I think that at bottom, that's a large part of what's going on here. But scratch the surface of that. And what it really is, the wedge issue is about exploiting fears in the community about demographic change. Okay? Arizona now has a population that is 1/4 Latino. That scares some people. And exploiting that fear is what's behind the politics of supporting SB 1070. And with respect to the first part of your question, I think it gives you a sense of how difficult it is to dance around answering some of these questions. Because the sheriff knows politically what the answer is he's supposed to give, but still betrayed the sense that he's going to target a particular group over others. And the notion that you can talk to a group of Latinos and determine from that whether they have reasonable suspicion or not is a part of what the major problem here is. I mean, we've heard crazy things from some elected officials that you can tell if someone's undocumented by their shoes, by their clothing, and it gets crazier from there. Of course, Jan Brewer thinks that half of undocumented immigrants are drug mules, despite the fact that the Border Patrol pretty quickly indicated that that didn't comport with reality. But that's how disinformed and misinformed much of this is. But the one thing that I wanted to say is, if this were actually implemented, police officers are going to face the threat of those private lawsuits that I mentioned in SB 1070 if they're not suitably aggressive in enforcing this law. They're also going to face the threat of a lawsuit by folks on my side arguing that they're engaging in a pattern of racial profiling. I can tell you, having been a city lawyer for the mayor for 4 years, that cities are going to look for the most careful path to avoid liability on both sides. What does that mean you do? I believe there are going to be some police forces that are going to adopt a policy of asking for papers from everyone. And I don't think that folks understood that. I certainly know Governor Brewer didn't understand that, because I certainly think she didn't understand that she was potentially putting a retired Scottsdale resident who hasn't seen her passport or her birth certificate or her driver's license in over a decade at risk of not being able to produce the papers that are required to get prior requests from law enforcement. So there are all kinds of unintended, very serious consequences of this law if it actually was implemented.
Second question. The undocumented are referred to as illegal, and it sort of presents the notion that there are two kinds of people in this coming in this country, illegal and legal. And it seems to me when you look at what has happened in this country in the last 20, 30, 40 years, heavily Latino, is that they have been sort of invited. The invitation said, if you can survive crossing the desert and all of the hazards and climb over the fence or swim over that water, we'll find you a job, we won't harass you, and we won't harass your employer. And in the law, it seems to me there is such a concept of kind of, I don't know exactly what the term would be, but a partially invited guest. And I wonder whether there's any merit to that kind of argument and whether it's used politically or whether it has any legal significance.
Well, I think it's absolutely true that there certainly has been a tacit, implicit policy of accepting significant numbers of undocumented immigrants because of a recognition, both in business but in government as well, that there are a number of industries, not just agriculture, that depend on immigrant workers, and they're not getting them through the legal immigration system. So I think there has been a tacit acceptance of this. Part of what put us in the problem that we have today is historically throughout our history there has been such a tacit bargain. But whenever the economy goes south, it seems like the bargain is revoked and there is renewed interest in trying to find and deport, remove the folks who are in that status. And let me just comment with respect to the first part of your question. I personally, of course, believe that reducing anyone to an adjective based on a single act is unfair and, in this case, discriminatory. But also believing that in some cases, particularly in politics, turnabout is fair play. Sometimes when I talk about these issues, I refer to Governor Brewer and some of her supporters as unconstitutionals. And in this case, it's not one act. They're recidivists when it comes to this stuff. They don't just pursue one unconstitutional policy, it's multiple. So I think it's a little fairer to refer to them as unconstitutionals.
Next question.
I think in the media we usually hear that the general population of Arizona is on board with this, but in fact they're not. And the mayor of, I believe, Yuma County, which is Tucson area, is adamantly opposed to this. Is there something, and has said, to my knowledge, that he's not going to enforce it. Is there something that we can do as Californians to support that effort and support them and let them know that they're not out there dangling by themselves?
Yeah, I think it's important to note that there are lots of folks in Arizona who feel under attack, and there are leaders who have stated their opposition to this law. The cities of Tucson and Flagstaff and San Luis have intervened in the lawsuit on the plaintiff's side to try to prevent this law from being implemented. And the sheriff in Tucson has made clear his opposition to this. There are indeed, the Arizona Chiefs of Police Association came out against it before it was enacted. It's important to note law enforcement's opposition because it tells you how dangerous this is from a law and order perspective. Governor Brewer portrays herself as a law and order candidate. This is about the law. What part of illegal don't you understand? Again, proper retort to that kind of rhetoric is what part of unconstitutional doesn't she understand? The answer is apparently every part of it. But for law enforcement, this is a very difficult proposition. They risk alienating the entire community and therefore face great difficulty in enforcing the other laws that they're supposed to be enforcing. But moreover, I think you'll find some law enforcement are so uncomfortable with this that they will leave Arizona, especially faced with the threat of lawsuit on one side, lawsuit on the other side. You don't want to do this kind of enforcement. There are going to be all kinds of opportunities outside of Arizona for law enforcement to be hired. So I think it is important that we find a way to express support for those inside of Arizona who are dealing with this on a daily basis, both the leadership and the people in the community who face great risks from their stepping out and marching against this and demonstrating their opposition to an unconstitutional law. They're out there on the front lines for all of us to defend the values that I talked about earlier.
Thomas, we here at All Saints have appreciated our partnership with MALDEF for many years over a lot of issues, and I'm so happy that you've been here today to reinvigorate our passionate commitment to you and to your organization. And it's nice to have a person like you that we can call one of the constitutionals in the country. Pardon my referring to you as an adjective. And we hope that you have many fruitful years in your post until President Obama or some other upcoming president appoints you to the Supreme Court. Thank you very much, Thomas Saenz.
Our mission at All Saints Church is to make God's love tangible 24/7, not only in the words on Sunday, but in our work and witness all week long. You can partner with All Saints Church in being a beacon of hope, compassion, and justice by making an online contribution today. Click on the Donate Now link on the Video Sermons webpage and join us and our friends from every corner of the world who are committed to turning the human race into the human family. Remember, it is in giving that we receive. And may God bless you and those you love, serve, and challenge today and always. Thank you.